And, I don't think Judge Hardesty is the kind of guy who would just throw out mere dicta in that calculation. What he did is he had.
All right, I want to say good morning to everyone, and let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Will Kemp, he's got that side. He's here, and Mr. Parker's on the screen.
Good morning, Your Honor. Joel Odou and Bob Eisenberg on behalf of AffinityLifestyles.com Inc. and Real Water Inc.
Morning, Your Honor. Dan Polsenberg and Abe Smith will be here too for Milwaukee Instruments.
Good morning, Your Honor. David Spurlock on behalf of United Natural Foods West Whole Food Markets.
Good morning, Your Honor. Elizabeth Lowell, also here from Milwaukee.
Good morning, Your Honor. Joe Reynolds on behalf of Hanna Instruments.
Good morning, Ramos Gali, also on behalf of Hanna Instruments.
Good morning, Your Honor. Ted Beers, also on behalf of Hanna Instruments.
Right, does that cover all appearances? I don't think so, does it? I saw checking. All right, once again, good morning. I see we have quite a few matters on calendar. Where should we start?
Judge, I think we ought to start where we left off, which was the motion for order confirming automatic stay and about the motion that we talked about.
Right.
Well, I think we should start with the 54B.
That's why I meant motion. It's 54B. I misspoke.
We think the same thoughts, Judge, we just use different words.
Well, I mean, they're the first two up anyway, right?
Yeah, Judge, and I've thought about it, and there's really no opposition to the 54B motion. Mr. Neal quibbles about whether the judgment is fine or not. I still think it's fine. Until we see the settlement agreement, we won't know whether it's fine. But that really doesn't matter if we're going to do the 54B cert.
No, it doesn't.
Yeah, I think the only potential issue is, I think, for Mr. Polsenberg's position, Milwaukee's, they would want me not to take action to execute in 30 days after the notice made for the 54B order. I assume they will.
Oh, yeah, good.
And so I think we will agree to voluntarily do that. And, we have our own selfish reasons. Specifically, we don't want any, if we do a execution on the bad faith rights, I don't want them going up on appeal and saying it was a flawed execution because I didn't wait 30 days. Okay. I mean, I just want to get rid of the issue. So we're going to voluntarily delay the execution until after 30 days after the notice of order on 54B. And as a further accommodation, if he wants his motion for order confirming automatic stay to remain on calendar, to remain filed but not on calendar. If he thinks I'm screwing around or something, he can come back and notice it. I think that would be a elegant way to solve the situation.
One has to appreciate elegance, Your Honor. And he is right. I would seek an appellate review, although it'd probably be by writ petition rather than an appeal. Rats, I was all set for today's argument on 54B. I even brought props. Here's my Beckley Singleton softball uniform. Notice on number 54B. And the name on the back is certifiable. I brought my Jeep's license plate.
You can tell that based upon the colors of that jersey, how old it is.
Right? The Marlins, like early 2000s. Yeah, but it kind of matched the Nevada Lake Tahoe license plate. That's 54B. Sorry, you guys are missing out, though. I doubt you're sorry. So yeah, I'll agree to all of that. I think there's one other.
No coffee cup.
No, you can have a coffee cup with me. There's one other implication, I think, of the 54B certification, since it's final now. Besides the automatic stay going out 30 days from written notice of entry of the 54B certification, the time limit for post-trial motions would also be given, and then 30 days after that.
Yeah, Judge, I thought about that too, and I don't care if they want to argue the motions now. Fine, I'm fine with that. If they want to wait and argue later, I'm fine with that too. Whatever they want to do.
Whatever the court would like to do.
Well, I believe in efficiency. You're here, so we should at least try to accomplish some of what has to be done. right?
Very good. If Dave shows up, we'll do that.
All right, so I just want to make sure. As far as the motion for an order confirming. The automatic stay and also the motion for Rule 54B certification. That shall be granted based upon the agreement placed upon the record. How's that?
That's fine, Your Honor.
Thank you, Your Honor.
Okay. So where do we go next? Because I mean, normally, unless there's an agreement, I just go in order.
Yeah,
That's how I've done it historically, right? Mr. Odou, I just go in order unless there's an agreement.
I don't think there's a lot of, in my order on my book, which is just how they made it, Your Honor, the costs are first.
Well, I'm looking here, this is on the docket. Next up would be 1281, right?
Which one's that?
That's plaintiff's motion for attorney's fees, costs and interest pursuant to Rule 68.
Yeah, we can do that one next year, Your Honor. I don't care.
Yes. Whatever you agree to, I'm fine with, but if there's no agreement,
We have no preference from.
Well, I have a little bit of a preference because Dave's not here yet, so maybe we could take up the motion to alter and amend on offset and prejudgment interest.
Whose motion?
That's mine.
Number 9?
No, that is my motion.
No, I'm,
we're looking at the list.
Milwaukee's motion for alternate amendment.
Which number is that? As far as docket number, what do we call it? Is it docket number?
1298, I believe, Milwaukee Instruments motions to alter and amend judgment pursuant to Rule 59E.
Is that really?
Grace indulgence. Okay, now that Dave's here, Your Honor, I think probably fees and costs should go last. What would make the most sense would be the 50B judgment as a matter of law that we just win. And then the new trial motion, and if we lose both of those, then the judgment is in front of you, and then we could take up the motion to alter and amend the judgment and for fees and costs.
Okay, so does that mean you want to do the real water motion for new trial first? Or you want to do Milwaukee or Hanna?
50B motion.
What's the docket number, Mr. Polsky?
I think that would be, I think he's talking about Milwaukee Instruments renewed motion for judgment as a matter of law, docket number 1297.
Yeah, that's what I showed too.
Your Honor, this is Joe Reynolds on behalf of Hanna Instruments. We were intending to collapse our argument on the renewed judgment as a matter of law with our argument regarding our motion for a new trial.
I mean, that's,
And 50B actually lets you do that.
I think he knows that, Mr. Polsenberg.
I'm stalling for time while Mr. Smith.
Yeah, Judge, I think since real water is the principal defendant, we ought to do their motions for new trial first.
All right.
Very good. Thank you, Ryan.
It makes sense in this type of case involving products liability and the manufacturer and distributor, right? Makes sense. All right.
1285 first, sure.
Okay.
Is that our final answer?
All right, and so for the record, I just want to make sure we're clear. We're focusing on that would be Affinity Lifestyles, DBA Real Water LLC and Real Waters Inc.'s motion to alter and or amend the punitive damage judgment, et cetera. Is that it?
I think that's the 1285. I think we probably would do new trial one first, which is.
Okay. Which one is that? 1297 or? no?
1284, I believe.
Okay, yeah, 1284. So this is. And for the record, docket number 1284, Affinity Lifestyle et al.'s motion for new trial and or any alternative to alter or amend judgment and remitted her and request to stay execution on judgment pursuant to Rule 62. Is that it, Mr. Odou?
Yes, Your Honor, that's the correct one.
Okay. All right, sir, you have the floor.
Good morning, Your Honor. Joel Odou on behalf of the Real Water defendants. I want to start with in our motion for new trial and remitted her. Some of the issues that we highlight in our briefing, the report looks at all the issues. Some of them, though, were fleshed out further in some of the subsequent pleadings filed by the parties. In particular, where we started our legal argument, might as well just address this one and take the bull by the horns, is we have argued that the Real Water defendants are entitled to an offset with the UNFW settlement. As the court will recall, there was no motion for good faith settlement filed by UNFW or by the plaintiffs. In fact, UNFW has insisted to keep their settlement with the plaintiffs confidential. They have filed it under seal, which we don't have an opposition to. But the reality is that the court's got to wrestle with those offsets, and they are kind of the elephants in the room. Because there was no motion under NRS 17.245, we don't believe, Real Water maintains, that the plaintiffs are not entitled to choose how that offset applies. In fact, that offset was filed in opposition to a motion rather than in an actual 17.245 motion before this court. So as an initial matter, we think the court needs to address this offset issue. The plaintiffs have come up with some creative calculations as to how they would like the offset to apply. But the problem with their calculations, in addition to not having any evidence to support it, is we don't have the underlying settlement. We don't have the underlying checks. As we pointed out in our reply brief to, I think it was the attorney's fees motion, to claim an offset for monies paid by insurance and then to maintain that that money was paid to settle punitive damages is problematic at best and probably not allowed under the law. In fact, it isn't allowed. And so right off the bat, we have this issue that is not fully briefed before the court because we don't have the settlement agreement. We don't have the checks. Is Mr. Belsky's settlement with UNFW, which appears to be in excess of the verdict for Mr. Belsky. That affects this motion for new trial. That affects our motion or our opposition to the plaintiff's motion for attorney's fees. And it sort of is pervasive throughout all of the arguments that we're going to make here today. The next issue that we raised was that the compensatory damages verdict was the product of, and I'm going to paraphrase, jury nullification. As the court's very well aware, throughout the course of the trial, there were issues where improper argument was made by Hanna in particular, alleging that the plaintiffs consumed poison. They put on Carl Savaggio for scripted testimony. Mr. Savaggio then committed what appears to be perjury. It certainly was impeached more than 7 times. We lost track. And that really left, and eventually their answer got stricken, and eventually they were on the hook for compensatory damages. Where this becomes relevant is it's pretty evident that that improper argument couldn't have been cured by a jury instruction, although we tried. And it appears to us that the compensatory damages verdict was influenced by the misconduct of Hanna in particular, and by also improper arguments by Milwaukee, which basically inflated the compensatory damages verdict. Making those inappropriate comments at trial definitely hurt Real Water. And we pointed out numerous times that it was not a cross claim. And so this was an attempt by the co-defendants to distract the jury and get the jury to only focus on Real Water rather than focus on the liability of the co-defendants. And it's unfortunate that they did it. We objected to it. The court issued some limiting instructions, and we don't believe that those cured the problem and that the ultimate compensatory damages verdict was excessive and it was influenced by passion and by prejudice and by the conduct of the co-defendants. And so we've raised that in our motion for new trial. The damages were definitely impacted by the continued attacks, calling the product poison. You don't put hydrazine in the water, et cetera. We detailed them all throughout our motion for a new trial. We then also pointed out where this entire trial pretty much wasn't over hydrazine, which Real Water acknowledged shouldn't have been in the water, but it was about all these other bad acts that purportedly occurred as to Real Water. We have an extensive testimony about all of these purported issues with other people making complaints. Those complaints weren't tied to hydrazine. Those were complaints just tied in general. We had complaints about different employees of Real Water. We had Tom Pham offering hearsay testimony over our objection about his neighbors going to the hospital for unknown reasons. He provided, basically, in our view, medical testimony as to the cause of their injuries. We had Jeffrey Dosatella going on and on about the injuries to his dog's plural, that they died. And then it comes out on cross-examination that they were 12 and 14 years old, and one of them fell in the pool. So yes, the dog died of water, but not from drinking real water. He fell in the swimming pool. And I know the court has read all the pleadings. I'm just giving the court sort of a high-level summary of all of those. But we think based on those improper arguments, that improper testimony, that it prejudiced the jury. And one final thing that the court was here and was present for was when we did our closing arguments, Real Water presented their closing arguments first. In front of the jury, counsel for Hanna then requested to use our demonstratives in their closing argument, tying us with them. We had no good option at that point. What are we going to say? No in front of the jury? So it was pretty clear that Hanna, after having their answers stricken and after having various adverse findings, continued to attempt to inflame the passions of the jury, continued to attack Real Water, really for no reason other than to try and distract it. And that ended up driving up the compensatory damages verdict. And so for those reasons, we think that the verdict was excessive. We think the court should either reduce it or grant a new trial. And again, I know the court's read all this. I appreciate the court's time. I'm happy to answer any questions that you have. But I think the biggest issue that, again, highlighted for the court is the absence of the offsets. And we have to do something about the offsets. Even if the court is not going to grant a new trial, the court has to take the offsets. They were attached to a different motion, but we got to address the elephant in the room, which is what type of an offset is Real Water entitled for the UNFW settlements, which were greater than the amount of the verdict from Mr. Belsky. What are the offsets that the meter defendants are entitled to for the Real Water settlement with Mr. Haley and the Gallaghers? And I think, honestly, Your Honor, it really should come by way of a motion for NRS 17245, but it didn't. And so it's kind of, we kind of have the cart before the horse, and now we got to fix it. And so for those reasons, in addition to the relief we requested in our original motion, because we didn't know what offsets were being claimed until we got the opposition and the motion for attorney's fees, we had asked the court to issue those rulings and correct the judgment. Thank you.
Thank you, sir.
Your Honor, if you're hearing offsets, that's also one of the two subjects of our motion under 59E. That would be docket number 1298. So if you want me to address that right now, that would probably be more efficient.
I have no objection, Dr.
All right.
So we have the same issue where the offsets are offsets need to be made, and they need to be made in an appropriate amount. Under 17.245.
I realize in tort law, you can't have double recovery.
Sure.
At the end of the day.
Right. Even in products liability.
Yeah, it doesn't matter. You can't have double recovery.
And we know that from the motor coach case. Now, the motor coach case on remand, my opposing counsel raised these same kind of arguments that the offset can't be for the same amount of the settlement because part of the settlement might have been for punitive damages, and they rely on the J.E. Johns case, the same case we rely on in our motion to alter and amend, saying we're entitled to an offset. But J.E. Johns was different. J.E. Johns was a case where the defendant, the settlor, was also liable for treble damages. So the Supreme Court said, well, the settlement had to be not only for principal amount, but for treble damages. And then a line or two in the opinion, they said that we have to take into account exposure, and that might be for treble damages or punitive damages. Well, I think this is an example of the law of unintended consequences, where the court went further than it had to in that case, and now plaintiffs here are taking it even further. There is not, treble damages are given. It's a statutory right, they're automatic. Punitive damages are not. So when they propose these alternate offset numbers, which are an exhibit, is not in the public record, so I won't give the numbers, but you can see they're coming up with these hypotheticals that.
And which, I just want to make sure I can find it real quick. Which docket number is that attached to?
It's 1351. So they're saying out of this settlement, we're entitled to an offset only for roughly 10%. And excuse my colloquialism, but that's just nuts, Judge. The punitive damages are not a given. They cite nothing to say that it's automatically part of a settlement. They rely on the word exposure in the appeal in the NCI case, and they say that exposure means risk. It doesn't mean risk. Exposure means exposure. If I die of exposure, I don't die of risk. I die of actual exposure to natural elements. So does a settling plaintiff who's liable for treble damages have exposure?
There's a distinction or difference between exposure in reference to how you're framing it, because, you know, whether someone died or not, that doesn't have anything to do with it. I mean, what's the difference between exposure and risk when it comes to settling a case?
Well, okay.
Why aren't they similar?
But they're not similar because to have exposure, you have to have exposure to something.
Well, you have exposure to a punitive damage verdict.
No, you have exposure to risk of a punitive damage verdict. Exposure, generally speaking, does not mean risk. There are only two areas outside the law where exposure means risk, and that's in risk management and rock climbing.
Well, risk management is a term of art used by the insurance companies on the insurance industry, right? That's risk management.
Right.
And that's their exposure.
Well, they use it as a shorthand, Your Honor. They use it when they say exposure, they mean exposure to risk, because everything about that business is risk.
Okay, how about this? Why isn't risk the percentage you could lose? Exposure could be the amount you risk by losing.
How do you quantify that?
Well, yeah, I mean, we quantify it every day in tort law when lawyers settle cases. They look at it, they make an analysis on liability, on damages, and they determine what their exposure is.
What their exposure to risk is.
Well, what their exposure is to losing a lawsuit. You can call it what you want to call
And
it.
it is exposure to actual something. Sure.
It is an exposure. What are you going to lose?
How do you quantify that?
Yeah, whether it's 75% chance of losing, and what's the case value? $100,000, maybe the appropriate settlement will be $75,000.
So they come in and they claim that the vast majority of the settlement was because of punitive damages, but they've got nothing that shows that. You know, at one point, the defendants have argued.
Why shouldn't I look at it through this lens potentially? Maybe look at it based upon an ultimate pro rata determination by me as to what the compensatory damages will be and what the punitive damages will be.
How do you assess that, Judge?
Oh, don't I I always have to determine whether or not there is a proportionality with punitive damages to the compensatory damages, right?
And forgive me, Well, proportionality after a jury has set
That's
them,
right.
and that's post-judgment.
This is post-judgment.
And that's got,
I
for
mean-
judge, it isn't.
Well, I mean,
It's
this is post-verdict. Don't
it's
play
pre-trial.
games. This is post-trial.
No,
And it's some-
not this number. This number is a settlement that,
No, I'm talking about where we're at right now. We're post-trial. And you want an
How-
offset, and I understand, and I respect you on that point. But the issue is, how do I deal with the offset?
that is the question I keep asking you.
Well, I can't come back, and I said, well, why don't I look at it from a proportionality perspective? I
And
mean, I
how do
don't
you
know.
assess the proportionality?
Well, punitive damages to compensatory damages.
And-
Are they
well,
10
that- I-
times? Are they 20 times? Do I reduce it under State Farm? I mean, what do I do? I mean, you were in here, ultimately, I had to reduce and what was it, the Dr. Desai case? I reduced the punitive damages by a significant sum, right? Ultimately resulting in a judgment.
That was an actual assessment by a jury. You don't have any jury assessment here. You
Don't I assess punitive damages
But when they're in
post-trial?
front of you, Judge,
But I
these
mean,
are-
I will.
These are not in front of you.
They
This
are
is-
in front of me. So you're saying you're accepting the punitive damages? That whatever the punitive damage award in this case is fine. Is that what you're saying?
Judge, I'm saying we're looking at a pre-verdict settlement.
I understand that.
And
I
there's
understand.
no
all
way
status
to
elements.
assess what that any portion of that is for punitive damages. And even if they don't assess it in the settlement. But even if they did, I would say it wouldn't be an arm's length transaction. So you are not in the same situation as treble damages, where the court can say 3 or 2/3 of a settlement would be for treble damages.
What's wrong with a proportionality discussion? And I don't know if that was raised, I don't remember that, but I say hypothetically, you have $10,000 in compensatory and you have 100,000 in punitives. 10 times
For
that.
what, Judge?
What?
For what?
For an event, for an accident, punitive
Okay, well,
damages, drunk
here's the-
driver.
I think you and I are at two different places.
And
I am
that's not surprising. Sometimes we are, sometimes we're not.
very often we are, and we have a lot of fun doing it.
Right.
But what I'm saying is, let's say you have a settlement for 100 units. It isn't allocated punitives and compensatories. And I would go so far as to say that wouldn't be an arm's length transaction, even if it were.
Why?
Because defendants don't care if the whole thing, a settling defendant doesn't care if the whole thing's allocated to punitives.
Still is an arm's length transaction. It's
No,
a
it isn't.
settlement. It's a settlement. It's arm's
I'm
length.
somebody, Judge, I've settled a lot of cases as a defendant. People say, I'd like to allocate all this to pain and suffering. And I say, you're on your own with tax consequences.
Yeah, but
I
that's a
don't-
diversion. I mean, it's an arm length transaction, a settlement.
Judge, it isn't.
Yeah, it is.
Not on allocating an agreed amount.
It's still an arm's length transaction. If it wasn't, there'd be fraud involved.
And if there was an allocation to punitives, I would argue that it is not a arm's length transaction.
I think a better argument would be, Judge, it's not binding on the court.
But it isn't even here,
Yeah,
Judge.
but you're saying it's not an arm length transaction. I don't buy that because the settlement is an arm length
Okay,
transaction.
but
you
we're
can say,
losing.
you're
we're
saying, look,
losing
Judge,
the
you shouldn't
point
bind
of
this.
the argument here, Your Honor. You've got a number in front of you. Since the numbers are sealed, I can't use the real number, so we'll say 100%, 100 units. So how on God's green earth do you allocate to punitives? Their suggestion is purely hypothetical. Kind of like where you're going and saying, well, 3/4 X could have been to punitives and 1/4 X could have been to compensatory. Of course, their current math gives me even less than that. But there's nothing, no rational basis for that. And I would submit, when we're looking at the idea that some of the settlement could have been for punitive damages, we're looking at a strict, excuse the pun, strictler situation. We're looking at a 17.245 where I get an allocation for the entire amount of the settlement.
All right,
Thank you, Rat.
you're welcome. Mr. Kemp.
Yeah, Judge, this, the Lindbergh issue, as Mr. Polsenberg noted, was raised in the MCI versus, or Giovanni versus MCI case. That exact issue is presently on appeal. I've already drafted my brief in opposition to their. I appealed. I can't remember where we're at in the briefing. I think your brief.
Judge Escobar ruled for us. They
Yeah.
filed the opening brief. Our answering.
Their answering brief is due.
Momentarily.
Momentarily, okay. In any event, this issue, I think Mr. Polsenberg's previewed his argument for me to the Supreme Court, but we're gonna be arguing this in front of the Supreme Court probably May or June, just guessing, or somewhere near there.
But
But
even if you waive a reply brief, I don't think we get an argument
Okay.
that fast.
so the issue here, Your Honor, is how do you handle the Lindbergh case? And again, Lindbergh's a case by Judge Hardesty, and it adopted an exposure test. And some of the things that Lindbergh said are instructive for us today. Quote, settlement offset calculations pursuant to NRS 17.345A1 must adhere to the statute's goal of avoiding windfalls, which necessarily includes restricting the settlement credit to the amount that fully compensates plaintiff's injury and does not otherwise provide for double recovery. So windfalls both ways. Plaintiff shouldn't get a windfall and the defendant shouldn't get a windfall. And so Judge Hardesty said that what the trial court should do is quote, or you're tasked with quote, scrutinizing the allocation of the damages awarded, unquote. You can't just do what Mr. Polsenberg says, just throw your hands in the air and let the defendants decide where they want to apply the credit. You have to scrutinize the allocation of the damages award and apply the exposure test. So in this case, we're focused on the exposure to UNFW, specifically the punitive exposure. Real Water argues that, quote, there was no substantial exposure to UNFW regarding punitive damages from its own conduct, unquote. And they say that the punitive theory against Real Water and UNFW was exactly the same. That isn't true, Your Honor. If you recall, UNFW filed a motion for summary judgment on the punitives and we opposed it. And in that opposition, we argued that they had an obligation to comply with the industry standard to do a third-party audit, which they did for half of their product, not the other half. That was what the punitive claim was based on. That was the exposure. If the court had granted that motion, there wouldn't be more exposure. There wouldn't be any exposure and the allocation argument would be different. But the court denied that motion right before trial. So UNFW did have exposure. So the issue becomes, first, are they entitled to a credit? We say, yeah, they're entitled to a credit, which is a little different than what happened in MCI versus Giovanni, because at that point in time, the law wasn't clear as to whether or not they'd even get a credit. But we conceded it's the same injury, so they get a credit. So the issue now is how do you allocate the credits? And it would be the credit for Mr. Belsky would apply to Real Water. They settled with Mr. Haley, so the credit doesn't concern them about Haley. And the credit for Belsky and Haley is of a concern both to Milwaukee and Hanna. So I say that the easiest thing to do, and this is supported by the Lindbergh decision, is to take the actual allocation that was adjudicated in this case. In other words, take the money that was decided by the jury to be punitives against Real Water and the money decided by the jury that was compensatory against Real Water. And let's see what the actual adjudicated ratio was. You know, this is not something the plaintiffs created. This is not something we're pulling out of thin air. This is what the jury did. And the jury, when you apply the 200 million and you compare it to the 21 million, it's 89% to 11%. So what we're saying is give them the entire credit, referring first to Real Water, but 89% of it would be applicable to the punitive damages, 200 million, and 11% would be applicable to the compensatory. I don't really understand why Mr. Odou cares which way it goes. But this is the way I care because it affects the Milwaukee and the Hanna calculation. And the exact same calculation has to be applied to Hanna and Milwaukee because that was the adjudicated ratio by the jury for real water. And true, real water isn't UNFW, but UNFW was the distributor for real water. And I think that that is the only sensible thing to do in this case. So that's how we would handle the allocation. We would take 89% of it, apply it to the punitive damages judgment as to real water, reduce it by that amount. And then we take 11% and reduce the Belsky amount as to real water by that amount. And we do the same 11% calculation for Haley and Belsky for both Hanna and Milwaukee. And that's what is consistent with Judge Hardesty. Now, Mr. Polsenberg is inviting this court to make the exact same mistake that Judge Escobar made. They told Judge Escobar that she could ignore the J.E. Johns versus Lindbergh case because when it said treble or punitive damages 3 or 4 times, punitive, I think 3 times, that was just mere dicta by the court. That was the basis for the decision, and that's exactly the words Mr. Polsenberg used. Punitive is, quote, mere dicta, unquote. And, you know, I don't think Judge Hardesty is the kind of guy who would just throw out mere dicta in that calculation. What he did is he had a case involving treble damages. That was a case involving a real estate sale. And he threw the punitive damages in there to illustrate how it should be applied. And so I think that would be a serious mistake to just throw out all J.E. Johns's language about exposure and allocation being required and just call it dicta like Mr. Polsenberg wants us to do. So for those reasons, Your Honor, we think that that's the way the offset should be handled. Now, offsets, there seems to be a misapprehension on the part of the defendant as to how you apply an offset. You do not apply an offset at the front end. And what I mean by that is we have to determine the total amount of the judgment before we do the offset.
Well, that's why I was bringing up my initial inquiry. Shouldn't we
Exactly, Your Honor.
make a
So-
determination. I have to determine what's going to be the punitive damage judgment, what's going to be the compensatory damage judgment.
And you have to do the compensatory first. So you
Yeah.
have to do the pre-judgment interest, the post-judgment interest, the attorney's fees, and then we have to have X amount for Mr. Belsky, X amount for Mr. Haley. And then we get to the issue of what the offset is. You know, Mr. Odou suggested that we just take the settlement amount and wipe out the jury verdict without doing all this other stuff. That's not the way offsets work, Your Honor. It's an offset. It's not some sort of credit that you get as soon as the jury verdict comes out. So the claim being made that the amount of the settlement is greater than the amount owed to Mr. Belsky and Mr. Haley, that's flat out wrong. Because when you add in all the prejudgment interest and the 40% attorney's fees, you know, I can't remember exactly what the Belsky and Haley amount is, but it's something like 3.4, 3.6 million. It's in that ballpark. The settlement credit does not, even if you gave them the whole credit, which you shouldn't, you should give them 11%. But even if you give them the whole credit, it doesn't wipe out that whole amount. So for that reason, we think that, yes, they are entitled to an offset. We're conceding the same injury, but it should be at an 89 to 11% ratio, which is the actual ratio adjudicated by the jury. Mr. Odou's next point. His next point was Hanna's misconduct. You know, first of all, he argues that the use of the word poison, which I decided not to use, was a Leochi violation. You know, as we pointed out in the brief, Webster's dictionary defines poison as, quote, a substance that through its chemical actions usually kills, injures, or impairs an organism, unquote. Well, hydrazine meets that definition. So we didn't use that term, but we don't think it was a Leochi violation in the first place. You know, Mr. Savaggio's testimony was problematic, but that was not testimony from a plaintiff, Your Honor. That was testimony by a co-defendant. So to suggest that we can throw out the whole jury award because a co-defendant went overboard a little bit, there's no case law that supports that. And finally, they asked for, and you gave a curative instruction. there was a curative instruction given that addressed this very same point. And so for that reason, and for the last reason, which, these defendants, they try to hold hands during the trial, but it's not uncommon during especially at the end of the trial, they start pointing their fingers at each other. That is not uncommon. We can't throw out verdicts for that reason. So for those reasons, we don't think that the Hanna misconduct should result in the whole jury verdict being thrown out. Mr. Odou seems to think that the jury verdict was excessive. We think it was pretty modest jury verdict. If you remember, acute liver failure is one of the most serious organ failures that you can have, similar to a stroke or a heart attack. The only difference is there's a limited range of treatment options for this. Either you stay in the hospital for 4 or 5 days, or you go get a liver and get better, or you get a liver transplant. They can't do what they can do with the heart and the others. So because of that, the medical bills are relatively low for an acute liver failure compared to those other 2 types of injuries. And so that seems to be their argument, that there's some kind of rule of law that if the medical bills are low, that they can cap a damages verdict at 5, 6, 7 times the medical bills, regardless of what the other injuries of the plaintiffs were. And in this case, we had Dr. Hudson testifying that there was permanent liver scarring on these plaintiffs. No dispute, most of them were in the hospital 5 days. I think, I can't remember how long Mrs. Arnone was in the hospital. It might have been as long as 9 days. But we don't think the verdicts were high by any stretch of the imagination, because basically the jurors got $2 million. Mr. Motiz, Mr. Haley, Mr. Belsky were in the 2 million range. Mrs. Arnone got a little more. Ryerson only got 7.5 million, a death case. We think those were really small verdicts, Your Honor. And the only evidence we had on verdict ranges, they didn't provide any verdict research in the motion. They claimed that, the verdicts are low based on their subjective evaluation of it. But we had the executive vice president testified that the verdicts are worth, this injury is worth $10 million. So the verdicts were about 20% of what their own vice president said that the injury was worth. And especially with that circumstance, there's no way the court should substitute its judgment for that of the jury. And then finally, on that point, we had a jury instruction, number 7, saying you can't be influenced by sympathy. And then now they come in and they argue that there was sympathy. Their last argument was the Mr. Odou made. There's others in the brief that I'll respond on our brief. I'll rely on our brief to respond to. But the last argument he raised today concerned prior incidents. The prior incidents were admissible with regards to the punitive damages claim against Real Water.
Didn't I do a detailed minute order on?
You did a detailed minute order on that, Your Honor.
I mean, I went into detail. I looked at all the Nevada cases as they pertain to products liability and just in a general sense, focused on what the prior Supreme Court would say would be admissible for the purposes of prior occurrences.
Right. And, they make the same argument they made all along, that you need medical testimony for each prior instance. That's not the law. They made a new argument in the reply that, you can't punish for harm to others based on the Philip Morris case. That's the United States Supreme Court case. Actually, the Philip Morris case says you can't punish for harm to others outside of your state. You can punish all you want for people in your state. But you can consider evidence of harm to others, even outside of the state. You can consider that for reprehensibility. So how is the jury to distinguish the two? Well, it's incumbent upon the defendant to ask for the Philip Morris jury instruction, which they didn't do in this case. And that instruction would say you can consider harm to others even outside the state for purposes of assessing reprehensibility, but you can't consider harm to others outside the state for purposes of punishment. Okay, that's the instruction they should have asked for, and they didn't ask for it. If they'd asked for it, we would have given it to them. And then they argue here in the opposition that the court should have come up with that on its own. I don't think there's any support for that. But with for those reasons, Your Honor, we think the prior incident testimony was admissible. I'd also point out the
I
majority.
mean, that was the ladder case. I forget the name of the ladder case. Remember with the latch? We had the Harley Davidson
Right.
case, and I went through all those cases.
Yeah, you had the, what was that ladders case? See, Mr. Pepperman walks out right when I knew.
Yeah, you tell them, Kraus.
Kraus, okay. So, yeah, we had Kraus, we had Harley Davidson, we had,
Or others that I
we had Guinness versus Mapes Hotel, you know, we had a lot of cases on that. Andrews versus Harley Davidson, I think. But, you know, and like I've already said, we cited the case law.
In the ladder case, they didn't even, the plaintiff didn't even know if they hit the latch
That's right.
or not,
Yeah. and
right?
In these cases, there's no dispute these people drank real water. And true, there was a lot of instances.
And I'll just make sure it's clear for the record. I remember some of the, although there wasn't a lot of studies, but one of the primary studies is related to hydrazine involved dogs.
Right. Right.
Right.
And also the Southern Nevada Health District report cited the injury to animals as a reason that led them to their epidemiological conclusion. So the suggestion that humans and animals had different exposures to hydrazine, I don't think is well taken. But for those reasons, Your Honor, we think Real Water's motion should be denied. And I think we're sneaking ahead on the credit argument that Milwaukee made. We think the credit should be given to them, but it should be limited to 11% of the Haley and Belsky verdict on the settlement amount, excuse me.
Thank you.
Your Honor, Joel Odou for the Real Water defendants. Just finishing up, the court will recall we argued the Kraus case and the other circus case and all the other cases about notice pretty extensively.
Wet and Wild, that's another one. Right?
And we addressed those. The court was very generous in its time, and I think we spent several hours actually discussing those other cases. And at the end of the day, we had argued that those cases were distinguishable. The court disagreed with us. We had attempted to distinguish them on the fact that in those different cases, the harm was obvious to a layperson. In this case, the hydrazine contamination was not obvious. It was something that nobody at Real Water had ever heard of. The court disagreed with our analysis, but I just point out that we had argued why those cases were distinguishable.
Well, but I think we have to remember the distinction between strict products liability and negligence cases. The thrust and focus in a strict products liability is on the product itself. And so whether they knew what ever happened before or not, notice type issues weren't germane to the ultimate analysis. And to a certain extent, everyone agreed that hydrazine shouldn't be in water.
We did agree hydrazine should be in
Right.
the water, and that's why we had argued that it wasn't relevant for the punitive damages phase because it was just prejudicial, and wasn't relevant because we had admitted causation and liability, and we had argued that it was prejudicial and it would inflame the jury against Real Water. And as I said, we tried to distinguish those cases. The court disagreed. The only reason why I bring that up is because counsel brought it up and the court inquired. I think the more interesting issue, or we think the more interesting issue rather, is the offsets and the continued argument about NRS 17245. I feel like it's Groundhog Day and we're back in construction defect court,
Right.
still arguing over good faith motions for settlement, which there wasn't in this case. And that to us is one of the key pieces of evidence that there was not a motion for a good faith settlement before the jury returned its verdict or before the jury panel was even formed. In fact, UNFW settled pretrial. And they settled pretrial confidentially. They chose purposefully not to do a good faith motion. They have kept the terms of the settlement away from Real Water. We don't know what the settlement agreement says. We don't know if there's an allocation in that settlement agreement. It's very troubling that we don't have that information. We don't know if the money was paid by insurance and if insurance paid to settle punitive damages, because we suspect that's not the case. And so for the court to simply take the settlement and wait until there's a verdict and try to fix this on the back end, we don't think the court can do that. We think there should have been a motion under 17245 if they wanted to make this particular allocation. The issue could have been fully briefed. We could have demanded, as we've continued to demand, the settlement agreement, the checks. we could see what was actually settled, but instead, what we're being told is it's none of your business. We're going to settle it confidentially without you. And we're going to tell you what kind of offset you get. And we're not going to give you any evidence to dispute that. And we think that's very problematic, Your Honor.
Here's my question, and I thought about it conceptually. And to understand this, many times, I guess all the time back in construction defect, when we handling those types of cases, when it came to the potential allocation of contribution and or indemnity, we would handle that in phase 3 after the verdict came back. And that was based upon the fact that the jury made a determination as to liability, percentage of liability amongst the respective parties, whether it was any contributory negligence and all those things. And so my question is this: when it comes to this type of issue, why shouldn't I give great deference to the ultimate determination of the jury, subject to any sort of adjustments I might make post-trial?
Your Honor, we believe those are two separate issues. The deference of the court gives to the jury as to the verdict or as to its findings, that's completely separate as to what was the settlement. They're asking you to interpret what the settlement was without having the necessary information to do so, such as the checks or the settlement agreement. In construction defect, and all the time, we have.
No, I understand that, where you're going there, and I'm not necessarily disagreeing with you, but I'm talking about the ultimate impact of the jury in this case when it comes to the assessment of compensatory and punitive damages.
And then I'll skip to that argument, Your Honor. As to that issue, as we pointed out, the piling on from the co-defendants had an influence as to the ultimate net verdict, and the fact that the Belsky $2 million.
I'll tell you this: I didn't understand the piling on.
Well, we felt that the jury was very.
No, I'm not talking about that. I'm talking about the co-defendants taking a position adverse to your client. I didn't understand.
Well, that part just didn't make sense, and it continues not to make sense. Because the more the co-defendants try to run up the verdict against Real Water, the more they're running up against themselves. And Your Honor, it's a.
There appeared to me to be a disconnect between the decisions and strict products liability law and the position they were taking. That's probably the best way I can say that, but go ahead, sir. I don't want that.
Yeah, Your Honor. No, we agree with you. And, you know, with strict products liability law, there seemed to be this misunderstanding by the distributors and manufacturers that they're strictly liable. And by piling on and by claiming that, look at all these bad things, they're just running up the ultimate verdict that they are equally responsible for. We had tried to prevent them from doing that. We'd objected to them doing that. They didn't have a cross claim against us. And so it was really an exercise in futility, and it ended up, in our view, just causing the verdict to be larger than it would have been. Frankly, Your Honor, we were left with no good remedies. There were various motions of various cases. I don't recall if there was a motion to sever in this case, but there certainly have been motions in other cases that have been denied. But it certainly seems that Real Water would have been better off going to trial by itself rather than having co-defendants continue to make jury nullification arguments, say, look how bad Real Water is, don't award a verdict against the meter defendants. And we think that's what happened, Your Honor. And so ultimately, that certainly drove the punitive damages verdict, but we also think it drove the compensatory damages verdict. And again, we think the offset does matter because we're going to argue the attorney's fees motion as to how it's allocated. We think 100% of it is definitely an offset that Real Water is entitled to. It's just a question of how much was paid for punitive damages. We don't think any, frankly, because insurance paid it. Typically, especially with an ongoing company, a large company like UNFW, to argue that their insurance carriers paid the punitive damages settlement rather than telling UNFW on the reservation of rights, hey, you're going to have to pay it, really stretches the imagination that happened. More likely what happened is the carrier stepped in and paid the settlement for the compensatory damages, not realizing there was a punitive damages element that they could have been on the hook for. They had their answer stricken. So they were going to get hit for a compensatory damages verdict in this case of some amount. And certainly that is a factor that probably drove their settlement more than this threat of punitive damages, because so far the meter defendants and the distributors have not been found liable by a court for punitive damages. So again, it kind of gave them the advantage of, we'll settle, we'll wait and see what the jury returns a verdict, and now we'll allocate, and that's backwards. They should have allocated first, done a good faith motion, and then the court could have addressed it head on without this taint of, hey, we don't have the checks, we don't have the settlement agreement. We don't really know what they paid for. Thank you, John.
Thank you, sir. Mr. Polsenberg.
Thank you, Your Honor. I'd like to join in Mr. Odou's comments on the offset issue. Let me go a little bit further.
You made it correctly?
Oh, I don't care.
Your Honor, I may have misspoke. I said UNFW got their answer stricken, all their experts got stricken. I misspoke. I apologize.
That's okay.
Great. So first, Mr. Kemp points out that I said the word dicta in MCI. Yeah, I did. You know, and I can go back to my high school Latin and say that it was dicta, where Justice Hardesty for the court was talking about punitive damages. It was not an issue in the case. It's not something the court had to decide. And I think they threw it in there as an example that if they'd thought about it more fully, doesn't work. And it doesn't work. Today in front of you, I used the English translation. I said the law of unintended consequences. And that's a phrase that Justice Hardesty used to use a lot. Let me give you an example. There was this case called Morsicato, and it was against the Kemp Jones.
I know all about Morsicato.
Yeah, well, you bet. You bet you do. And I petitioned for rehearing in front of the court in Morsicato. And I said, look, I accept I lost, but you need to change the wording of that opinion because somebody somewhere is going to argue an extension of it. And the Supreme Court denied rehearing on the basis that nobody ever would. And then in the case in front of you, the Williams case, they argued exactly what I had predicted. And it went up to the Supreme Court, and the Supreme Court said, no, Morsicato doesn't go that far. Here, I would say J.E. Johns, he calls it by the respondent's name, Lindbergh, I call it by the appellant's name, did not go that far as to say anytime there's an allegation of punitive damages, you have to figure out what the offset is rather than give a full offset. You talk about proportionality, Your Honor. If they had specified in the settlement what amount went to compensatories and what amount went to punitives, maybe you would look at proportionality under those circumstances. I don't think you do.
But does that ever happen when it comes to a settlement? Because
no, and it hasn't happened here.
well, no, that's not my question. You're saying, well, Judge, if they would have allocated pursuant to the settlement agreement, what portion of the settlement goes to punitive and which portion of the settlement goes to compensatory? I mean, that never happens.
It never happens, and
Well,
I'll tell
but
you why.
but
I don't think it happened here.
But if you look at the settlement release language, and typically in all settlement agreements, it says settles any and all claims.
No,
Right?
there are cases that allocate what the settlement monies go to. They could have done that.
But my question is this, I mean, and shouldn't I look at the settlement agreement in this case? What does it say? And here's my point. Number one, I clearly believe there should be an offset. So I'm not gonna even.
I don't think anybody in this room says anything different.
Is it, yeah, it's just how I determine.
But that's not the $64 million.
Yeah, I understand, but that's kind of my question. I mean, it should. Okay, well, I'll throw it out there.
Let me go back to my thought, though.
Okay, but let me go back to my thought. What if the settlement agreement says settles any and all claims?
Of course, it settles any and all claims. No defendant or insurance company is going to settle some
I
claims. and not all
agree,
claims.
but my point is this, if it says settles any and all claims, that includes compensatory and punitive damages.
But what Mr. Odou just talked about is it's naive to think that an insurance company is paying 3/4 of a settlement for punitive damages when generally
Well,
speaking.
actually, he said it different than that. He said, Judge, look, we all know that when you settle with an insurance company, you settle compensatory damages. That's what he basically said.
And I'm relying on what he said, but
I mean, I
plaintiff's
get that.
position,
I
plaintiff's
get that.
position,
I get that. I have respect what Mr. Odou said there. I do.
plaintiff's position is that 3/4 of that settlement. No. Here they're saying 90%.
Yeah, 89%. Yes, absolutely.
Well, you're better at math. So 89% of that settlement was for punitives. An insurance company is not going to do that. And they don't come in and show you the allocation because, you know, if they did allocate it 89% to punitive damages, that would be taxable. They're not going to do that to their clients. So there hasn't been an allocation here. There isn't something for you to look at proportionality under. And they seem to be doing the US Supreme Court due process less than 10-to-1 ratio. I say that ratio.
That's a State Farm case out of Utah, right? Is that the case?
It was from Utah
Yeah.
up to the Supreme Court. There are a line of cases.
Yeah, but that was
Judge,
a proportion. I get that. That's a State Farm case out of Utah. No more than 10.
my point is, that's not the ratio that applies to my defendant.
I get that too.
No, you don't get it.
Yes, I do. You just don't realize.
I do not think that this is a products liability case against Milwaukee. I think, and we've made that clear during trial. We've made that clear in our 50B motion. I think you're looking at a negligence case. This isn't products liability. We didn't make the product. We didn't make a component part of the product. They're saying that we made an instrument that tested what the product was, but that's not strict liability. So the proportion you'd be looking at here is 3-to-1 under the Nevada statute.
So you're telling me that, you know, Judge, all that time you spent on jury instructions and focusing on the product insert and the warnings or the failure to warn, that was this negligence. That's not a defective product and reasonably dangerous under the restatement of torts 402A.
You want the short answer?
I mean, I understand your position, but I just want to make sure the record's clear because we spent a lot of time on that.
Hey, Judge, this was maybe negligent failure to warn, but 402A doesn't apply in these circumstances. And we have a motion later today on that. So at the time of the settlement, I don't
Was
think
that argued when we were settling jury instructions?
it was argued on a 50A motion.
No, but was it argued when we were settling jury instructions in this case and a negligence instruction was proffered by your client?
We don't need to propose a negligence instruction for them if they don't want to go on
No, I'm
negligence.
talking as far as your case is concerned and objecting to a strict product liability. I just want
Made
to
a
make sure.
50A motion, Your Honor, which is all we're required to do. I didn't want the case to go to the jury on negligence. I didn't want the case to go to the jury at all.
Well,
But
yeah.
we did want dismissed their products liability case.
Didn't they have an expert that
A law
testified for
judge?
3 minutes and 51 seconds, something like that?
46 seconds, Mr. Odou time.
And have an expert on domestic law, Your Honor. So if you look at these allocations, they weren't at the time of settlement. There's no allocation to punitives. I don't think that all the defendants were in the same position, either as UNF defendants or Real Water. And if you look at the Belsky and the Haley UNF settlements, I mean, those settlements weren't just 100 units, they were 10 times 100 units. And they've still worked out a way that we only get an offset for 10%. So I think all of their funky math is inappropriate, Your Honor. Thank you, Your Honor.
All right, anything else? And do we deal with, it said all erroneous calculations of interest pursuant to, is that something later?
That's later. That is in the motion that I said we could do first. So our motion on interest calculations, Milwaukee's motion, has both offset and interest calculation, but I'll consider the offset part submitted to you now.
Okay, this is what I'm going to do, and I just want to make sure I have the correct motion. Right? Just 1 second. Oh, thank you. And I just want to make sure I'm clear. We've gotten a little bit astray, but this is Affinity Lifestyles motion for new trial and any alternative motion to alter or amend the judgment and remitter and request to stay execution of the judgment pursuant to Rule 62. Is that correct, Mr. Odou?
That's right, Your Honor.
Okay. And we have an agreement as far as the stay of execution and the like. Is that correct?
Yes, Your Honor.
Okay. Just want to make sure I'm not.
We have a stipulation extending the time for real water that's separate and apart from anything we're doing today.
As far as the motion for a new trial, I'm going to deny that. And it appears to me, and we spent a lot of time, and I can't criticize anyone for their defense strategies, but at the end of the day, this case is handled as a strict products liability case, and the thrust and focus is on the product and also the those entities involved in the distribution claim. I mean, distribution chain. So I'm going to deny it. As far as the allocation of potential settlement with a couple of the plaintiffs, I'm going to not make that determination today. I'm going to wait until the very end and decide what the offset should be. One thing I am going to consider the tension between the jury verdict and also the fact that an insurance company settled the case. And what impact does that have as it relates to punitive damages? Anything else? Same for the joiner. All right, what's next?
I'm sorry, Your Honor, this is Teddy Parker. Are you denying Milwaukee and Hannah's similar motions at the same time?
Yes, they were joined in, yes.
Okay.
Your Honor, this one.
You want to argue it? Is that it?
Joe Reynolds for the record, Your Honor. To be clear, you're denying to the extent that we had a limited joinder to Real Water's motion.
And not any independent motion?
Correct.
Yes.
Is that correct?
Yes.
Okay, thank you.
Because I'm going to give you a chance to argue that.
Thank you, Your Honor.
Mr. Reynolds, you've been in front of me enough to know that I'm not going to cut you off, sir.
I do. Thank you.
What's next?
Judge, we have a real water motion on the punitives. You want to do that next? Should be pretty quick,
Whatever,
right?
yeah, whatever.
Mr. Reynolds, you are right, the limited joiner, 100%.
We're going to do 1285 next.
Whatever you want to do, Mr. Odou.
Your Honor, just, are we going full day today? By the way, I didn't know the schedule. Are we trying to finish at lunch? I just wanted to preview that.
Well, one thing we do have some time, right? And what's your recommendation, sir?
Your Honor, I have absolutely no objection to doing my motions today and sitting in the back bench if we don't finish the other motions. That'd be just fine with me. I just didn't want to hog the spotlight, so to speak.
I think we should try to accomplish as much as we can. I was thinking about this, breaking at noon, maybe reconvene at 1:30, maybe go to 3:30, something like that.
Great.
Is that
Pleasure,
good,
Your
sir?
Honor.
I think Mr. Polsenberg mentioned he has some,
Mr. Polsenberg, what do you have, sir?
I mentioned to Will that we have our firm's pro bono lunch. There's no way on God's green earth we're going to be able to work around that for this hearing.
When is that? When do you have to leave, sir? Now?
I'll skip that. We'll just go ahead, Judge.
What time is it?
11:09.
Okay. I mean, I do think that's somewhat important, sir.
And I appreciate that, Your Honor, but I don't want to tie up everybody just because Abe's winning an award.
What time do you need to? If you left at 11:30 and came back at 2, would that be okay?
I do not want to inconvenience the court. Let's just go ahead.
No, Mr. Polsenberg, I'm here till 5 o'clock anyway, so it doesn't matter. I
No,
mean,
it's-
it's not like, it's not like we're getting ready for trial right now.
Right,
It's-
well, as Judge Guy used to say, I get paid by the year, I don't care how long it takes, but
That's very true.
yeah, but no, let's go ahead.
It's up to you, sir.
Thank you, Your Honor, I appreciate that.
I mean, if you wanna, we can break it 11:30.
No.
Come back at 2. Because we're gonna come back again and again.
Yeah,
not gonna get
I
done.
have today and Wednesday blocked off for this hearing.
Okay. But I'll give you your last chance.
Your Honor, you were always too kind. Your remarks to Mr. Reynolds, I was thinking, yes, that's true. You give everybody the chance to make the record, and I appreciate that. But I decline your graciousness, although I do note it.
All right. So I guess we'll work through noon and then we'll take off and we'll come back at 1:30. Is that good?
Thank you, Your Honor.
All right. So I guess next up would be motion to alter or amend the punitive damage judgment. Is that correct?
That's correct, Your Honor. I just page on what the docket number was. That is docket 280 or 1285.
Yes.
Thank you, Your Honor. Joel Odou on behalf of the Real Water Defendants. Just picking up where we left off in our reply brief, I think we addressed sufficiently, although certainly we'd be happy to answer the court's questions, a procedural opposition that the plaintiffs had as to our motion under NRCP 59E and NRCP 59. We'll rest on the pleadings as far as that part goes. Your Honor, as to the punitive damages element, this court's very well aware, it was a $200 million punitive damages award. And at the start of jury selection, we had argument from counsel about could the jury award $1 billion in punitive damages. We had multiple arguments in voir dire about what type of verdict the jury could award for punitive damages. And in fact, even in closing arguments, we had a request for $1 billion in damages. And the plaintiffs attempt to justify the $200 million punitive damages award by the purported reprehensibility of Real Water. And as the court's very well aware, we had argued that punitive damages in this case need to be tied to something other than just the reprehensible conduct or purported reprehensible conduct. The testimony was very clear. Nobody had heard of hydrazine at Real Water before it was found in the water by the FDA. And while it's certainly intent, motive, those sorts of things are important for punitive damages, we understand that the court said, look, it's strict products liability. It's water, it shouldn't be in the water. And that was conceded by Real Water. In fact, what we had argued that that type of evidence and the both the admissions by Blaine Jones and by Brent Jones that, you know, people got sick and that they were sorry about that was important for the ultimate findings of fact by the jury. But instead, what we got is we got an entire argument about the amount of punitive damages that are incomprehensible compared to the amount of revenue of Real Water. As the court will recall that we had attempted to introduce evidence that the best years of Real Water before COVID, at best, they had revenues of $9 million a year for about 3 years total. And that evidence was ruled inadmissible because of the bankruptcy of Real Water. Plaintiffs then, in opposition to this motion, went to great lengths to talk about insurance and insurance issues and all of these things. And as we put in our brief, it's really not relevant. The issue before the jury was the punitive damages as to Real Water, not some insurance company. And the issue was to make an award that was reasonable and just and would compensate the plaintiffs for the compensatory damages and would punish or deter not every water manufacturer in the country. And the plaintiffs have used the fire sprinkler example as to send a message, but to punish and deter Real Water and not others, not before this court, such as Coca-Cola, for Dasani or Fiji or any of these other multi-billion dollar companies. And so, Your Honor, it's very clear that the jury verdict of $200 million in punitive damages was excessive. And we had asked the court to at least reduce that based on the evidence of the case. Certainly, the evidence supported a much smaller award of damages, not $200 million in punitives, when you've got a company that never made $200 million in its entire existence. As I said, at best, the testimony was that they had revenue for about 3 years of $9 million, and then the company had taken a pretty good financial hit post-COVID. In fact, Blaine Jones didn't even have health insurance and had to do a GoFundMe page for his own health insurance. And we had introduced evidence that, in fact, he didn't have the money to pay his own medical bills. And so to think that a company like Real Water could pay $200 million in punitive damages is just outright wrong. And it was caused by improper argument that, you know, we need to send a message to the bottled water industry. And we had argued that that was excessive. We had argued in jury instructions that we were going to have an excessive punitive damages award. The court had expressed some concern in jury instructions that there would be argument about other things that didn't come up. But again, we had argued also about excessive punitive damages. And that's what we got, Your Honor. We got a verdict not based on any evidence, a verdict based on only argument. And in fact, there was no evidence offered in the punitive damages phase, as the court would call it. The parties went directly to argument because all that evidence had come in the prior phase. And that was another reason why we felt that the prior verdict for compensatory damages was improperly influenced, because basically the plaintiffs got all their evidence in and didn't need it in the punitive damages phase. And so for those reasons, Your Honor, we think the punitive damages award is highly excessive. You know, again, we could talk about multiples, but we have a compensatory damages verdict as to Real Water, depending on how you slice it, of about $20 million, give or take, because Real Water had settled with the Gallagher family and Mr. Haley prior to the verdict. But that's neither here nor there, because obviously the statute allows for a punitive damages verdict that is more than at least twice the compensatory damages. But that's not what we have here. We have one that's 10 times the amount and then some. So for all those reasons, we think the court should reduce the punitive damages verdict. We think it was a product of basically passion and of sending a message to Dasani and the bottled water industry when it should have been a message to deter Real Water. We have a question?
No, sir.
Thank you very much, Shane.
You're welcome. Did we have jointers on this one? I don't think so.
No, the punitive damages was only asked to Real Water. And
Understand.
Yeah, Your Honor, starting with the procedural issue, we'll rely on our briefs too, but I would note that this is a pretty serious procedural issue because 59E relief's limited to 3 grounds. 1, newly discovered evidence, that doesn't apply. 2, the court committed clear error and made a decision that was manifestly unjust. I don't see any argument that applies. And 3, there's an intervening change in controlling law. That's not the case here either. So for those reasons, we think there's a procedural reason to deny this as set forth in our opposition. Moving to Mr. Odou's points that he expressed today. So his suggestion again is that he should have been able to allow to offer 4.5-year-old financials of a defunct. His words, he calls himself dead, bankrupt company. So he wanted to offer 4.5-year-old financials when in addition, we had agreed that we wouldn't pursue the judgment against Real Water. That's part of the bankruptcy stipulation. So it was kind of a charade. He wanted to present to the jury that supposedly anything over 9 million would punish him when he's already dead and bankrupt and he knows we can't pursue it. So I think the court's ruling on financial condition was appropriate because there was no financial condition. What kind of evidence could he present on financial condition? And then you couple that with the fact that they didn't raise annihilation as an affirmative defense, which they should have. Remember, if the court remembers, they tried to amend it at the last minute, the court didn't allow it. And I do mean the last minute, I think it was right before the punitive phase started. So for those reasons.
And would you even consider annihilation with a bankrupt company?
How are you gonna consider annihilation defense when they say in their pleadings that they're dead and they're bankrupt? I mean, how do you raise an annihilation defense meaningfully within the meaning of Ace Trucking and the other case law? So now they flip over and they say, oh, this is excessive, Your Honor. 200 million is a lot of money. It's a 9.49 to 1 ratio. Okay, that's it. I mean, actually, I think Mr. Odou did a pretty good job keeping it down to 200 million because that's only 9.49 to 1. And the constitutional cases, BMW versus Gore and State Farm, the court's already referenced, their language is single limit. Most state courts and other federal judges expand upon that and allow things up into the range of 12 to 18. The Nevada Supreme Court case law that we cited, the 2 insurance cases, those ratios are 12.4 and 12.5 to 1. So we're under all of this. So that's why I would say Mr. Odou did a pretty good job keeping it down to 200 million. But I don't know.
I think in the decide case, I reduced it from, I forget what the exact number was, but it was
I think
20. I reduced it to right around 10 and a half, 11.
right. It was I think it was 18 or 22 and you chopped it,
Right.
Which and even though I lost 200 or 300 million in one day, I didn't bitch. I just that's it. Okay. Right. But I respected Your Honor's decision. But
I just wanted to be in line with State Farm.
right.
That's all I wanted to do.
And
be in line with
the
State
same thing here. You're at 9.49 to 1. If it was 19.49 to 1, I would fully expect your Honor to chop it a little bit, but we're not. We're 9.49 to 1. And so for those reasons, I think the motion should be denied.
Farm. Mr. Odou?
I think it was 156 million I lost that day. Yeah.
I just wanted to conform with the constitutional mandate of the State Farm case out of Utah, because I think that case was very straight, hot off the press right around that time. So,
Your Honor, certainly we don't want to take money out of Mr. Kemp's pocket. That would be wrong. The attorneys need to get paid. However, I think the 9.49 or whatever they calculated actually includes the Gallagher judgment, which we settled with the Gallaghers. We're still trying to resolve that for some reason, but the Gallaghers settled out prior to trial. And so that $6 million verdict for Orion Gallagher and the $1 million verdict of $500,000 each for the 2 parents doesn't go into the fact that, Your Honor, we pointed out in the Mathias case, which was out of the 7th Circuit, that ratios of more than 4 to 1 are suspect, constitutionally suspect, and that it cited the State Farm case. And so, Your Honor, again, $200 million punitive damages verdict against a company that had revenue, not profits, revenue of at best $9 million a year for 3 years, and at worst actually didn't have profits because it ended up declaring bankruptcy, is intended to punish them. It's intended to send a message to Dasani or send a message to Avion or send a message to some other real water or some other water manufacturer rather than punish or deter real water. And the plaintiffs point out, well, that evidence didn't come in, and that's exactly our point. The jury had to have some evidence to render a verdict. It can't just in a vacuum and argue render a verdict on punitive damages without something to hang their hat on. Yes, they have the alleged conduct of real water, but they don't have the information that they would need to send a verdict that is just and fair and not one that's based on simply passion and argument and not evidence. And for those reasons, we think the verdict should be reduced.
here's my next question. What do I do under a scenario where the main target defendant is in bankruptcy? What do I do under
Your
this?
Honor, and that's why we had proposed the court. That's why we proposed to the court that it was important for the jury to have some type of financial information. We had argued, and the plaintiffs argued just now, that it's stale financial information. Well, if that's the best evidence that exists, that's the best evidence that exists. And that gives the jury a factual basis and actual evidence to make a punitive damages award. Instead, that evidence didn't come in. And so there was no evidence as to the financial basis of Brew Water. And without financial information provided to the jury, then the jury's verdict becomes nothing more than prejudice and speculation, and it's not based on evidence. A $200 million verdict is virtually meaningless when they don't have context to put it in. And since the jury never was provided that evidence, which we had proffered, but it was rejected because the
But
plaintiffs
if
didn't
I
want to
take
put it
that,
in there.
here's my question, if I take that to a natural extension, every time a defendant goes into bankruptcy potentially, their financials might not come in, and that would be an automatic basis for not permitting a jury to assess punitive damages?
No, instead, what we're saying is the jury needs some evidence. And if the best evidence, or in this case, the only evidence, happens to be financial information that is out of date, that's better than no evidence at all. Some evidence is better than no evidence. And what we had here was no evidence. And that is the problem in our view. Yes, we understand. In fact, that's why we had proffered it. We didn't want the court to say, well, you're leaving them with no alternative. They had an alternative. They could have offered evidence as to the financial status of Brew Water at its best. So there's no prejudice to them by having the absolute best financial information for the company. The prejudice, frankly, would have been to Real Water. You know, here are the 3 best years where we had $9 million in revenue. Instead, they chose to have no evidence. And that's the problem. And that's where we challenge the verdict, because the verdict is not based on evidence. We have deleted from the jury instruction over the objection of Real Water the financial status of the defendant, which is necessary for a punitive damage award. They talk about the annihilation defense. That's not our only objection. It's not the annihilation of the company. It's the jury has to have some evidence, something to hang their hat on.
But isn't the basis of permitting financials to be introduced at the time of trial, at the time of the punitive damage phase, the reason for the financials is a concern about annihilation, right? And so if annihilation is not asserted as an affirmative defense, why would the financials even be germane and or relevant?
Because it's not the only basis. Annihilation isn't the only basis. That's what we keep saying. We keep saying the jury has to have evidence as to what would be a dollar amount to punish that defendant. It's not just the, this dollar amount or that dollar amount would annihilate that defendant, but a different dollar amount. They have to have some context. They have to have a ballpark which they're going to play with. So they got to say, okay, this is the relative financial status of a defendant when the wrongful act was committed. That's evidence that could have been provided to the jury. The plaintiffs chose not to provide that to the jury. And that's the problem. It's not just the annihilation. It's the fact that the jury needed to have and was not given some frame of reference as to what amount of money would it take to punish Real Water. So the jury was left to assume that the amount of money that would punish Dasani would punish Real Water. And yeah, a $200 million verdict would punish Dasani. A $200 million verdict would punish any $1 million or multi-million dollar or billion-dollar companies. But that's not what we had here. We had a small family business that at best grossed a couple of $1 million a year. And we have a punitive damages award that is not based on any of that evidence, but instead is based on argument of sending a message to the bottled water industry. And that is where the verdict lacks evidence. And that's why we believe the verdict should be reduced.
Right.
Your Honor, this is Teddy Parker.
Yes, sir.
And I apologize. I know hey, how you doing, Joel? And I know the last word goes to Joel, but the only thing that was not mentioned by Joel or Mr. Kemp, and perhaps this was on purpose, was that NRS 42.005 subparagraph 1 indicates that compensatory damages and punitive damages in particular may be used to recover damages for the sake of example and also to punish the defendant. So there's a component where the amount can be used to set an example of what misconduct will not be tolerated. And so I don't want the court to not consider what NRS 42.005 says in its entirety and only fixate on where Real Water is directing the court And it's this annihilation issue that they did not bring up as an affirmative defense. And then the other thing I wanted to remind the court, because the court gave Mr. Odou this opportunity. If you want to argue that you have no real financial ability to handle a punitive damage claim, then wouldn't the plaintiff be able to bring in front of the jury that there's an insurance company out there providing coverage that would pay this amount given the bankruptcy resolution? And of course, Mr. Odou didn't want that option. And so we went with what I thought was a compromise position between Real Water and the plaintiffs in how this was presented. And the final thing, Your Honor, right before we did arguments on punitive damages, Mr. Odou came to the bench. We all came to the bench. The white noise was put on. And Mr. Odou said, listen, I'm concerned about certain arguments being made. And both myself and Mr. Kemp stayed away from that argument. So I truly believe that what we put before the jury on punitives was, I thought, an agreed upon approach. And it took in consideration NRS 42.005. Thank you, Your Honor.
And I just have one quick question for you, Mr. Parker. What was the subsection of 42.005 you were referring to at the very beginning?
Yes, Your Honor. It is 42.005, subparagraph 1. It's the first paragraph, and it says the purpose behind punitive damages. And it says, for the sake of example, and also by punishing the defendant. So you're using it to make an example so that big, small, medium companies don't act similarly, exposing, in this case, people to toxic or poisonous water.
Okay, thank you, sir.
You're welcome, Your Honor.